नीचे का हल्का बहुत वो
Now, my lord, your lordships will see the title is Application of Act to Properties Given or Donated by Persons Not Professing Islam for the Support of Certain WAQF. Now, kindly see, my lord, the original act that your lordships will see on the next page in a footnote. Permit me to read it, my lord. Notwithstanding anything contained in this act, where any movable or immovable property has been given or donated by any person not professing Islam for the support of a waqf, being a mosque, idgah, imambada, dargah, khanqa, maqbara, Muslim graveyard, chowdhury or muzaffar, then such property shall be deemed to be comprised in that waqf and be dealt with in the same manner as to the waqf, as the waqf in which it is composed. I'll make a point on this in a moment, my lord. Then kindly turn to section 23. I'll just read, my lord, the now, if your lordships will see that it says there shall be a full-time chief executive officer of the board to be appointed by the state government who shall be not below the rank of so-and-so. Now, my lord, kindly see the original section. There shall be, at the bottom of that page, my lord, there shall be a full-time chief executive officer of the board who shall be a Muslim. I won't read the rest, my lord. There are at least 12 sections of this act which deal with the powers, duties and responsibilities of the chief executive officer. One more section and I'll make one or two points, my lord. Now, my lord, kindly come to section 2. This your lordships will find on page 5.
जी चलिए ठीक
The lordships will see that a proviso has been added, provided further that nothing in this act shall, notwithstanding any judgment, decree or order of any court, retrospective, apply to a trust by whatever name called, established before or after the commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for a purpose similar to a waqf under the law for the time being in force. Well, Lord, I won't elaborate other than judgment after judgment of your lordships, Lord, have indicated that a waqf can be in the form of a trust. And eventually, earlier, my lord, the board decided whether it was to be a trust or whether it was to be a waqf. Now, this was a very important provision, my lord, right from Ratilal, the first decisions of your lordship, 7-judge bench. There has never been any doubt that if your objectives were in the form of a trust, similar, those are the words used here, my lord, similar to those of a waqf, this will entirely and completely disappear. Now I will make, my lord, two very general points. My lord, earlier, supposing I am a WAQF, my lord, and I create a trust which has objects similar to that of a waqf, it would be in the past treated as a waqf. Now, my lord, many, my lord, WAQF put their objectives, ultimately remember, my lord, it's the object of charity, object of religion. Now, if the object of the trust is similar to that of a waqf, and there were a large number of them across the board, my lord. Ratilal, my lord, is the case from Bombay. It dealt with the charity commissioners, and the issue once there was whether the charity commissioners would have control or whether the waqf board would. And your lordships ruled that if it is similar to a waqf, then, my lord, it is not the charity commissioners who will appoint, my lord, the custodian.
With the board.
With the board. Or the board as it then stood. Now, this is an important takeaway, my lord, because a large number of waqfs are in the form of trust. What this does is, what was earlier a matter of form has now been removed as a matter of substance. Just 3 points on that, my lord, and 2 additional points I want to make.
What you are trying to say is basically that any trust would not be a waqf anymore.
That's right. Even if it is similar, even if it is, my lord, trusts are in their own area.
That's right.
There is a distinction between the two. But if it is similar to the nature of a waqf, it would be treated as a waqf. And there are a large number of such throughout India. Now, my lord, I have 2 more points to make, my lord. My lord, Mr. Sibal has already indicated, and this has never happened, my lord, in the past, of the redefinition of a religion and religious property. Never before, my lord. We go back to the Board of Revenue of 1810, my lord, of the East India Company. They didn't change the nature of the waqf property. Neither 1817 in Madras, nor in the 1923 Act, my lord, nor in the 1994 Act, nor in the 1995. What was the occasion, my lord, for this large-scale liquidation of the very concept of waqf? My lord, no religion in the world can survive apart from belief, practice, property. You take that away and no religion will have any longevity at all. So this goes to the heart of every religion, and it is only the Muslim religion where this property has been dealt with in this way. But that is not my only point, my lord. The important point is, my lord, it's an issue not just, my lord, as far as this is concerned. My lord, we are a secular nation. One of my clients, my lord, in the writ petitions not listed before your lordships, happens to be a Sikh. He says, I want to contribute to waqf. I believe that this property should not be taken away. This is an issue which goes fundamentally to the question of secularism. Because Article 25 and 26, and I would add Article 29, the preservation of one's culture. That's right. Article, well, not 29 as well, which is the right to preserve your culture. How would you preserve it, my lord? You preserve it on the basis of your beliefs, you preserve it on the basis of your practices, and on the basis of the property that sustains these beliefs and practices. Take that away, my lord, the entire secular edifice which your lordships, my lord, have built from time to time and time again, my lord, will also become suspect. One last point, my lord. Mr. Sibal has dealt with, my lord, classification, manifest arbitrariness. My lord, when you justify these changes, what is your justification? What your lordships, my lord, have laid down is the doctrine of proportionality. Where is the proportionality? Now they, on the other hand, says there is better effective management. At one stage in the counter they say certain persons were not registering as waqf by user. So, my lord, the question that your lordship might put to them is, you want to achieve certain goals, it has to have a nexus that's established. Where is the proportionality behind the changes that you are now making in relation to the objectives to be achieved? And my lord, across the board, no justification has been given as far as proportionality is concerned. My lord, I adopt the rest of the arguments.
It was a pleasure hearing you after a long time.
I know, even in my throaty voice. My lord, there's one small point, my lord. This act is in the teeth of a large number of constitution bench decisions of your lordship. Charity, Ratilal, Babri Masjid, my lord, para 1131, which says waqf by user is a part of Islam. So it's in the teeth of a number of constitutional. Now, my lord, your lordship interpreted in TMA by the meaning of the word establish and administer.
It's 1134 paragraph.
1134. That is in M. Siddiq, my lord, the Babri Masjid case.
2021 SCC, page 1.
So, my lord, now, my lord, the question as to whether educational establishments also came in TMA 5, in para 25 and 26 of TMA 5. The phrase is establish and administer. I have a right to establish, my lord, under 26B of the Constitution. I have a right to administer. Those rights, it is stated way back in 1954, no legislature can ever take them away. That's all. I'm very clear, right?
So I will finish even before possibly the end. Very pointed.
Bear down your.
It's difficult to navigate what is left over, and I'll try to just give you lots of points without repeating this.
Whole shift.
Incidentally, well, it's the first learned judge who could be heard holding his own court in Supreme Court and other courts came from my state. And the second learned judge, well, two learned judges, well, who could be heard in other courts. One from Rajasthan in the old days, and then one from Mumbai. Justice Tulsapurkar, Justice Bhargav, who was the uncle of Justice Suresh Agarwal. They are the two learned judges who could clearly hear in those days. Anyway, now, well, the first point, and I'll make it only point formulas. 3R, you know, you will see. Just pick up 3 small r for a second. Now, 2 points have already been made in the text of it. This is page 7 of the Act, perhaps. The 2 elements there are, one, proof of your practicing Islam. And the second is this delightful word, contrivance. So the first thing is, Willis, that you can never apply, look at the word, Willis, and that there is no contrivance involved. It's a recipe for making the applicant visit the offices of the collector or the officer for eternity, trying to prove that there is no contrivance involved. It's the most vaguest, arbitrary, completely whimsical word used to invite terror, control, and endless visits to the government office. Second, people of all religions make religious endowments. All. And India is planet Earth's most diverse spot. Which other religion, at the point of making a religious endowment, by whatever name called, is asked for proof of that religion's professing and practicing? For 1 year, again 5 years. For 5 years, for 10 years. Which religion? Point number 2. Point number 3. That brings in directly an article not really directly mentioned, Article 15. This provision goes on the short ground subject to my Lord's discretion of violating Article 15. Textually, it is a discrimination on ground of religion. Religion X and its donors and its creators of religious endowments are asked for proof of their religion, which is directly contrary to Article 15, which Lordship knows very well, Willis. out of 7 or 6 tests, the first word is religion in 15.1. The state shall not discriminate against any citizen on grounds only of religion, comma, and this is only religious, race, caste, sex, place of birth, or any of them. Religion is the first. And it is singular, Manas, in its novelty. The state is discriminating by using parliament to pass a law, and therefore that law is unconstitutional. Whereas my second point relates to the WAQF by user point and goes slightly beyond. It has already been made, I only want to fill up a gap. By its very nature, WAQF by users were largely unregistered. At some point of time, a requirement came to give particular register, be there side permanent. Whereas the sub-point in 3C and all the other provisions here is the access to court point, the remedialness point. Now, my learned friend has already shown to your lordships the arc which connects 3C, 36.7, 36.7a and 36.10. That must be kept in mind. And it's a vicious circle that once you cease to be WAQF, you cannot exercise the remedy, principally because you're not a WAQF. So it's trying to catch your tail. The ground, this arc is very interesting, just let us pick up 36. 3C, my lord has seen, dispute. The counterpart of 3C is found in 36.7a. My lord has noted that. There also a dispute means you're not a WAQF. So one principle is in this act. The moment there is a dispute, a WAQF, so-called a WAQF established, a WAQF 500 years old, ceases to be a WAQF.
That's what,
Both 3C and 36.7a.
that's what is the similar also.
Yes, but I am not on that Guru. I am now on the access to justice. Right? Now the moment you cease to be a WAQF, there is no question of registration or unregistered WAQF moving a court. And the bar of 36.10 applies in full force. That's why my Lord Bernard read to Worship 36.10. So I say it makes a vicious circle that any dispute, and the dispute can start tomorrow. It doesn't have to be a pre-existing dispute. It doesn't have to be a dispute leading to a decree or a appellate decree or a Supreme Court decree or prior to this date. It can be a dispute started tomorrow. I can start a dispute tomorrow. So that is clearly exclusionary. Now what I am going is one step further. I heard an interruption saying that 36.10 was always there. That is more than true. Please note what was the 36.10 predecessor. Give this note. Come on, quickly. This is not a note for reading, but it's just for the quotation I have given you, so it will be easier. Please ignore all the text. I am not giving it to the side. Can I read a provision of statute from a note?
Yes.
Mr. Mehta, I hope that's not your best point, Mr. Mehta. Now let us come to page, kindly come to page 4. Till now I have not read the note, but I am in terror. I am reading only the provision from the note. Para 7. Now this is important. But let's just don't read it for a minute, give me a reference. In the 1984 Act, there was a bar of initiation of proceedings.
You are reading paragraph?
Well, it's 7, at page 4 of this note. Just the quotation I am using it for. Does that not happen? See the underlined portion. Unless such WAQF has been registered. Right, brothers? Now your lordship will note the next line. The amendment was not brought into effect is an admission and a fair statement by Mr. Mehta at page 36 of his counter, para 55. That italicized statement by me is a quotation from Mr. Mehta's counter, page 36, para 55. I hope I am clear with this. So broad ouster clause was never brought into effect according to the counter.
Now, the next provision quoted is a provision in the 95 Act called Section 87. I hope there's a misprint there, that section should be 87. If there's a misprint,
That is correct.
correct it. I'm grateful. Now, this is another, the words are not identical, we are not concerned with that. Again, another kind of ouster. See the underlined portion, unless such WAQF has been registered. Right, fellas? This was deleted by the 2013 amendment. That's why I say it's more than a half truth. From 2013, this deletion stands. This vicious circle of connecting 3C, 36.7, 36.7a and 36.10 starts only with this 2025 regime. I hope I am clear on my second point. My third point is about that ancient monuments where Mr. Ahmadi has made a very comprehensive note which I will not go into. Yes.
This side will have to conclude by 4 o'clock.
I will conclude.
We have already granted more than.
I have started at 3:35. I'll conclude.
No, we don't know.
No, well before that I'll conclude.
Well, we had said 2 hours, but we are getting more. If we continue till 4 o'clock, we will be giving more than 3.5 hours.
I will conclude, my Lordship. May not doubt that at all. 100%. Even if I don't conclude, I shall conclude.
No, the others are in waiting. Everybody would like to.
Now, let me just say what I wanted to say on this, just for a minute. On 3D,
No,
I'll try and leave.
no, not more than 4.
Let's finish. Let's use the time we have.
Yes. Since 20 minutes are left, we thought that Dr. Singhvi would be generous for others.
My lord, 4 minutes for me, my lord, because I have.
This will take away my 20 minutes, so let me finish as soon as I can.
After that, my lord, finish. My lord should consider that.
Now, the 3D, number 1 was 3D. All the other facets of 3D are not repeating. That has been argued. 3 capital D. It would, read as it is being read by the government, would even circumvent and impinge upon the Place of Worship Act, 1992. Clearly. Your Lordship reading it differently is something else. I'm not concerned about how Lordship read. That of course can be protected. Lordships can read it. As textually framed and as argued, this non-obstant situation in 3D, superimposing Ancient Act, Monuments Act onto this, superimposing 2025 Act on the Ancient Monuments Act, has a direct result of affecting even those protected by another special act called the Place of Worship Act 92. Effect of the Places of Worship Act 1991. I'm sorry, 1. Because something, let us say, a character of a place of worship which is X religion, Y religion, Z religion, is shut off on a cut-off date. Today, by a notification here, for example, for Muslim places of worship, you will create a situation where at least your Lordship will have to work it out. Otherwise, on a literal interpretation, it will override that. The second point on that is
So work out what? Work out what? You said that we will have to work out.
no, your Lordship, unless absent your Lordship's interpretation that the Place of Worship Act protection on a cut-off date remains a Muslim place of worship, a place of worship. Well, I am arguing Place of Worship Act. I am not arguing Ancient Monument. I am saying if you notify under the Ancient Monuments Act.
According to him, by superimposing
Yes.
the Ancient Monuments Act on the by 2000
The declaration
Act
under D.
also affects the rights available to the citizens under the Right to Worship Act 1991.
It's not even an argument. I'll deal with it.
It is my argument, not your argument.
But
Because you haven't.
it is a pleading.
It is a pleading. It is a pleading. We'll give that also. Take it out. It is a pleading.
In fact,
Because
override all other laws.
a monument which is a monument which is protected under the Place of Worship Act can be declared
under a notification under 3D. That is the point I made.
There is no notification.
He opens the word notification, allow me to have my 15-20 minutes, let me have my fundamental right to say wrong things.
15-20 minutes?
No,
You decide upon it.
he is not allowing me my fundamental right to say wrong things, Your Lordship. What do I do?
Then
He is interrupting me every sentence.
we don't mind, but then we will not be even after
I'm
that.
trying to finish with this. The next point here is Article 15 comes in again. Because on 3D, Your Lordship has chosen one religion in this Act. Not Your Lordship, the Act has chosen. One religion.
But this Act itself is applicable to one religion.
That's right. Now this
Very
particular,
choosing one.
this Act applying this interpretation of the Ancient Monuments Act to one religion is what hits Article 15. That's my point. The fact that 3D textually applies the Monuments Act on this Act and this Act on the Monuments Act is only for one religion. That's Article 15, Manas. Your Lordship is considering prima facie constitutionality and whether to give Manas some interim orders. Therefore, this is very relevant.
Yes.
Now, Manas, this is as far as 3R and 3D is concerned. Lordship may also note that Your Lordship knows the law very well, that Your Lordship doesn't normally grant a stay. But look at the language Your Lordship used in the Farm Act's case. Kindly hand over that case. Bernard, in that case. Rakesh, give it to me. 2021, 1 SCC 590. Rakesh Vaishnav, about giving us, we are not asking for a stay on the whole Act. We are talking of the provision Lordship has heard us on. All these provisions. My Lord has said this about the whole Act. Kindly hand it over.
This was an unopposed order, we conceded. Let us be clear and honest about it. Justice Bobde's order, Manu.
I can't be clear and honest about anything before opening the book and reading the case. Kindly turn to us. Para. Just give me 1 second, brothers. Para 10, 11 and 14. If my Lord comes to 10, let us see what the learned Attorney General said, and let us see that the last interruption of Mr. Mehta was right or wrong. Please turn to para 9. Para 9. It starts at when we put across above suggestions. Got it, brothers? Your Lordship got that? Para 9 starts like that. The learned Attorney General, even while agreeing for the Constitutional Committee, vehemently opposed the grant of any stay of the implementation of farm laws. I don't know what that English language means. Next page. Continuation para. The learned Attorney General contended that the court should not stay the implementation of the laws. Therefore, para 10. Though we appreciate the aforesaid submission of the learned Attorney General, this court cannot be said to be completely powerless to grant a stay of any executive action under statutory enactment. Even very recently, Jayashree Lakshman Rao parted. Now come to 14. I agree with us, Your Lordship doesn't grant it for the asking. But if there is one act, one statute, one case which cries out for certain absolutely sinister provisions requiring to be said, this is it. Having heard the different perspectives, we deem it fit to pass the following interim order with the hope and expected both parties to take the right spirit attempt to arrive at a fair, equitable, just solution. The implementation of the 3 farm laws, all the laws are listed, last line, shall stand stayed until further orders. As a consequence, the minimum support price in existence before the act shall be maintained. We are asking for much, much, much lesser. We are asking for much lesser. Then, brothers, Your Lordship's recent judgment on 300A, authored by Justice Gawai, Chief Justice Gawai Malas just a few weeks ago. I'm not saying that Malas is all, just note the citation. 300A.
Karnataka Madam.
Yes, called Malas Bernard Vaz. 2025 SCC online SC20. Don't read it, just bear with it. Kindly note the citation. Court master will give it. Paras are 42, 43 and 56. The important point is that your lordships could have decided on the Karnataka statute about delayed compensation. My lords made it a point in para 42, 43 and 56 to say that what must imbue your lordship's interpretive approach must be 300 capital A. Namely, how you will interpret a provision, what will be the effect of that interpretation if it is expropriatory, and we have shown in detail what is expropriatory. I don't have time to repeat that. It will be imbued by what your lordship calls in those paras 42, 43 and 56. It's not a mere statutory right. It's a constitutional right. It may not be a fundamental right, but it's much higher than a statutory right. That's what your lordship says. So kindly note these three paras, 42, 43 and 56. Manas, your lordship has got this thing about increase of trust by 100%, etc. properties. Just note this, fellas.
The 42, 43 and
56. Whereas it is said, one of the arguments in the counter is that there is a huge surge in WAQF properties. Suddenly a huge surge, explosion in numbers. Just note the answers were ABCD. A, the loading on a portal which they have created for listing WAQFs started in 2013. The loading onto the portal. That is pointed out in my rejoinder at page 5. What should we just note it for saving time. Therefore, as the portal was populated over time, the numbers had to increase. Before that, you had no population on that portal. They are treating an increase in the portal population of listing as an increase in WAQFs. An updation exercise. Number 2, the learned Minister of Minority Affairs on 18th of July 2019 at the rejoinder page 60 of Mr. Ayubi's file. Mr. Ayubi's writ at page 60 has the answer to an unstarred question. He says we have increased now and are proceeding day to day on increasing digitization. So what is being prejudicially suggested to your lordships to increase numbers of WAQFs is actually an increase in the portalization and the digitization. Thirdly, there are many properties in a WAQF area sometimes. They were treated as one WAQF property. Now each is listed separately. This is all stated in my rejoinder. So let us not have these prejudicial arguments in the counter that there is again and again a lot of prejudicial arguments are given. That you must have more and more, you are having a explosion. Your lordship should be aware in this note. Just turn to one fact. We always talking the abstract about registration and non-registration. In this note at page 2, extract from the JPC. Let's see this, the note I gave. We are talking in the abstract about registration, non-registered, work by user, etc., etc. 2 figures only the lordship will note. This extract at page 2 for the state of Bihar. Now the Bihar WAQF board filed a document before the JPC. It's only extract from there. It is an annexure to the JPC. It's extract from there. Out of 20,000 mosques, only 5.98% are registered. Just note that one line. And
not
second page, which is an extract. And the second line is, on 27,000 graveyards, 3.6% are registered. This is from the Bihar WAQF board's written submission and annexure to the JPC report. And note my learned friend's counter with annexure at 195. Mr. Mehta's. Page 195, PDF page 197. He says 50% roughly are WAQF by user. The figure he gives is 8.72 lakh properties, of which 4.02 are WAQF by user. Only that one line also save time. His own counter, annexing as part of the JPC extracts, says that. There are some more things, but I'll give it in a note if necessary. Well, it's one last thing, and after I'm ending. But it's just these pages. Reference will also be note because we have time to see it. The reference I gave last was about the 195 of the counter where the election is given, which says out of 8 lakh, 50% are WAQF user. Now, there's 2 more statistics that I'm done. Para 80 of Mr. Mehta's counter. Para 80 of his counter says those works which have not been registered nor have they been found in existence during the survey by the Survey Commission, their claims are not maintainable at this belated stage. This is para 80 of his counter. The emphasis of the word survey by the Survey Commission. Well, as your Lordship will note, the JPC report at page 92 points out that survey is done only in 5 out of 28 states. It's a travesty. Just note the reference, page 92 of the JPC report. My friends, counter doesn't point this out. 5 out of 28 states and 4 out of 8 UTs. This covers JPC.
Filed a note with new facts.
I have not filed a single note. I am quoting from your counter. Now let us. I have quoted from your counter and the JPC report. Please don't misrepresent. Please don't misrepresent. Now, 9.3% of the area of the country as a whole is what these 5 states and 4 UTs represent. You do a survey in 9.3% of the area. In your counter, you say that in our survey we found no registered works. Your survey is only in 5 out of 28 states. And then you try to shut me out. I'm deeply obliged.
May I just take 2? I'd like to take 2 minutes. There's one aspect which your lordships